disclosure of records and information. There are three criteria for disclosure. There's a child under the age of 12, a child between the age of 12 and the age of 18, and if they are over 18. And there are different criteria for when this information is going to be disclosed. Now, I get it. Most of your EAP referrals are going to be from the workplace to the employee, but a lot of you are also going to be doing work with family members and the like, and so it's important that you know. Under the Confidentiality Act, either parent has the right to authorize the disclosure of information of a child less than 12. Now, the statute says either parent, and the case law construes that as in fact any parent who has not had their parental rights terminated or in reality restricted by way of something like an order of protection may restrict a parent's access to mental health or health care related information. As long as they have the status of a parent and have not by a judicial order had that taken away from them in some way, they have a right to the information of a child under the age of 12. The problem comes up when one parent says yes and the other parent says no. And the one case that dealt with that was In re the Marriage of Markey. And that said, and its progeny has said that really whichever parent says yes wins. So if mom says yes, disclose, dad says don't disclose, dad has the right to disclose. But the parents or the other members of the family who are involved as collaterals to the services provided to a child under the age of 12, their information, although it may be contained within the record of a child under the age of 12, is not to be disseminated without the release of each of those parties. So example, if you have a child and the child is brought by mom on a weekly basis to your office, and you come in and say, hi, Mrs. Nye, how have things been with you and Jonathan the last week? And Mrs. Nye says, well, Jonathan got into a fight at school, he bit off someone's ear, and he got into a lot of trouble. And you grab Jonathan by the shoulder and say, let's go back and talk about it. That information that you derive from Mrs. Nye would be information derived from a person, not the child. And if dad, for example, came in and wanted to get that information disclosed, dad cannot authorize the disclosure of the information derived from mom. So he may have the right to disclose the information derived from the child, but not from a collateral or significant person. Now, that does not mean that if a child's social worker from school or some third party communicates with the mental health provider, that information would not be disclosable without that social worker or third parties signing off on a release. What it means is that any significant person who is participating in therapy for the child or with the child as a collateral, they still have the right to their own confidentiality and the right to restrict the disclosure. Now, there are no provisions for a guardian ad litem or a child's representative, for example, in a juvenile court proceedings or in a divorce-related proceedings, or theoretically, if you're involved in some sort of a probate-related case, in a guardianship case or the like, of a child under the age of 18. So there is no provision for it in the Illinois Mental Health and Developmental Disabilities Confidentiality Act that authorizes a guardian ad litem or a child's representative to release information if the child's under the age of 12. Now, that is not the case if the child is over the age of 12, and we're going to address that in the next slide. If a child is between the ages of 12 and 18, first of all, I think of them not as children between the age of 12 and 18. I think of them as teenagers. And any teenager is going to have an issue. And the statute specifically states that if the recipient is informed and does not object to a disclosure, or if the therapist does not find that there are compelling reasons for denying access, then under those circumstances, the provider of services can disclose information between from the teenager. Now, the problem I have is that we all know that teenagers are basically not consistent reporters. They are not reliable, and they may say to the therapist they don't object, and 5 minutes later they do object. And so I advise all of my clients who are dealing with recipients who are between the ages of 12 and 18 not to disclose without their written authorization on a release of information. Now, that failure or right of the child between the age of 12 and 18 extends to information being received by their parents. So a parent of a child who is a teenager can be denied access to the child's records, either by the therapist or the provider of services, or by the child themselves. And that seems like a lot of power to be placed on the shoulders of a 12-year-old, but that's reality. And the reality is that if a parent is denied access by either the therapist or the recipient, now this part is our secret, they may petition a court for access to the record. Now, you don't want to end up having to defend such a case, because if it turns out that the information that was withheld by you, as in the therapist, is determined by a court to have been inappropriately withheld, then it is within the court's discretion to require that you pay for the reasonable attorney's fees of the parent wishing to get that record. And I'm just letting you know I'm as reasonable as they come, at least I think I am, and even my fees are unreasonable. So it is my advice that if a child authorizes the disclosure, that unless you feel that there is an imminent risk of harm, that you not withhold disclosure and place yourself in that position. If, on the other hand, the child says, no, don't disclose, you have an obligation to protect that child's interest, even at your own detriment. But I have never seen, nor do I expect to see, a situation where a child specifically says, I do not want this information disclosed, where a court would say that the therapist would be on the hook for the attorney's fees for that therapist proffering or arguing that right of the child, which you theoretically have an obligation to do. So I'm just letting you know, be careful how you make that choice. And that's a time to get some consultation. If it's a child who is a teenager and there has been an attorney or a guardian ad litem or what's called a child's representative appointed, either in a marriage and dissolution of marriage case or a paternity case, or in theoretically a case involving juvenile court, that person who is a guardian ad litem, attorney for the child, or child's representative can get an order from the court that appointed them that grants them access to the record, which is superior to that of a parent. In other words, they can have authority of a child over the age of 12, under the age of 18, which is even greater than a parent, because they are the eyes and the ears of the court when they are an appointed attorney under those circumstances. If it's just letting you know, I had communicated that a child does have a right to restrict information which may be disclosed to a parent. If there is a restriction, a child says, I don't want the therapist to disclose information, and mind you, whether this is under alcohol and substance abuse or the provider, or it's a mental health provider. And keep in mind, I don't know of any circumstance wherein someone receiving alcohol or substance abuse treatment is not also receiving mental health treatment, and I don't see how it cannot be so intertwined as to be able to differentiate one from the other. So as far as I'm concerned, if you're receiving alcohol or substance abuse treatment, it falls within the Confidentiality Act, as well as the alcohol and substance abuse confidentiality regulations. So if a child insists that their information not be disclosed to a parent has an absolute right to the following. And if I was going to write something down today, this would be what I would write down, because this comes up an awful lot. The current physical and mental condition of the child, the diagnosis, treatment needs, services provided, and services needed, including medication, if any. Now, what's missing is really the gravamen of the therapeutic process, and that's what the kid said to the therapist and what the therapist said to the kid. And if that information is not disclosable, then under those circumstances, the parent gets what I personally believe an insurance company should make their decision on. Wouldn't it be great if the only information by legislation, the only information an insurance company would have a right to in making their determination as to whether or not they should pay or not pay a particular claim for a session is the current physical mental condition of the child, diagnosis, treatment needs, services provided, and the services needed, including medication, if any.